Imagine you're a comedian on stage, right? You tell a joke about the President of the United
Oh,
States.
high stakes right out of the gate.
Exactly. So the crowd laughs, the broadcast goes out to millions, and then the very next day, the leader of the free world publicly threatens you with a lawsuit.
Wow.
Yeah. Do you apologize? Do you retract your statement? Or, do you stand your ground and hide behind the Constitution?
That is the ultimate question, isn't it?
It really is. And when people talk about free speech today, they invoke the First Amendment almost like an involuntary cultural reflex.
It is like a magic word.
Right. It's thrown around in social media arguments, town hall meetings, cable news panels. We treat it as this impenetrable shield to protect our own expression and, simultaneously as a sword to wield when we feel wronged by what someone else has said.
That the reality is much more rigid.
Right. When you strip away that mythology, what does the First Amendment actually mean under United States law? Today, we are bringing that question into a modern context for you by looking at a recent cultural flashpoint involving comedian Trevor Noah and President Donald Trump.
A fascinating case study.
Before we go a single step further, we are maintaining strict neutrality. Looking at this very highly publicized, very politically charged clash, we are maintaining strict neutrality. We are not here to take sides and definitely not endorsing any viewpoints. Our goal today is just to act as a guide to how the legal and constitutional framework's at play.
What's fascinating here is that to truly grasp the mechanics of this pop culture moment, we have to deliberately slow down and dismantle our assumptions.
Yeah, we have to clear the board entirely.
Precisely. We have to strip away what we want the First Amendment to do or what we feel it, should do, and look exclusively at what the legal text and centuries of jurisprudence actually dictate.
Because it's not what most people think it is it?
Not at all. The First Amendment is not a blanket permission slip for all human communication. It is a highly calibrated, deeply specific legal mechanism.
Okay, let's unpack this. Because the gap between public perception and legal reality here is, well, it's staggering.
It really is.
When you read the actual text, the First Amendment primarily states that Congress shall make no law abridging freedom of speech or of the press.
And that word Congress is the hinge everything turns on.
Right. Over the centuries, the Supreme Court has interpreted that with a very specific laser-like focus, which is that government actors cannot punish or restrict speech simply because they find it distasteful or offensive.
And that distinction is where most people get tripped up. The First Amendment was engineered to protect the people from the government.
Just the government.
Exactly. It was never designed to protect people from each other. If you say something wildly offensive, heavily exaggerated, or even entirely false, the Constitution does not automatically shield you from social consequences, job loss or civil lawsuits.
So it only restrains state power.
Right. The boundary it draws is strictly around the state.
Yeah.
The government apparatus cannot step in to act as the censor.
So it's essentially like a bouncer at a club, but a very specific kind of bouncer.
I like that analogy.
Right. So the First Amendment stops the government from acting as the bouncer and kicking you out of the public square just for complaining about the music.
Right, right.
But it absolutely does not stop another patron at the club from yelling back at you.
Exactly.
And it also doesn't stop that patron from taking you to court if you stand up and falsely claim to the entire room that they stole your wallet.
That analogy holds up perfectly. And that is where the architecture of the law gets incredibly complex.
How so?
Well, the courts have established boundaries where speech loses its constitutional shield entirely. We are talking about highly specific, very narrow categories.
Like what?
Things like true threats of violence, incitement to imminent lawless action, and defamation. If your speech falls into one of those zones, the government can and will impose severe legal consequences.
Which brings us right to the edge of the Trevor Noah and Donald Trump dispute. Because we are squarely in the territory of defamation here.
We absolutely are.
For anyone listening who might be fuzzy on the modern application, defamation isn't just about insulting someone, right?
No. Insults are protected.
Right. It's about making false statements presented as fact that actively harm someone's reputation. But looking through our sources today, the bar for a public figure to actually prove defamation is, it's shockingly high.
It's immense.
It almost seems impossible to reach.
It is intentionally designed to be nearly impossible.
Wait, really? Intentionally?
Absolutely. To understand why, we have to look at the absolute bedrock of modern defamation law, which is the 1964 Supreme Court case, New York Times v. Sullivan.
Oh, Sullivan, that's the big one.
The biggest. This case fundamentally re-engineered how defamation works in America. The Supreme Court declared that public officials, and this was later expanded to include all public figures, must prove a concept called actual malice to win a defamation lawsuit.
Wait, if actual malice is the standard, doesn't that just mean Donald Trump would have to prove Trevor Noah hated him or was acting out of pure spite when he told the joke?
That is the assumption most people make.
Because malice literally implies anger or ill will.
Right. But in a legal context, actual malice is a terrible, highly misleading name. It has absolutely nothing to do with whether the speaker likes or despises the target.
So what does it actually mean?
To prove actual malice, a public figure must demonstrate with clear and convincing evidence that the speaker either knew, for a literal fact, that their statement was false when they made it.
Oh, wow. So they knew it was a lie.
Exactly. Or that they acted with a reckless disregard for the truth, meaning they basically entertained serious doubts about the truth but published it anyway.
That feels incredibly counterintuitive.
In what way?
Well, the Supreme Court intentionally designed the law to make it vastly harder for powerful people to protect their reputations. They are actively setting up a system that allows false statements about public figures to circulate with less legal risk.
That's precisely what they did.
That seems entirely backwards. Why would the highest court in the land make it harder for a wronged party to seek justice?
Because they were looking at the survival of democracy itself. If you look at the historical context of the Sullivan case,
Which was the 1960s, right?
right, Southern politicians in the 1960s were weaponizing defamation lawsuits to bankrupt civil rights leaders and the newspapers covering them.
Ah, so they were using the law to silence the press.
Exactly. The Supreme Court realized that if the threat of a financially ruinous lawsuit hangs over every single critique of a public official, it creates a massive chilling effect.
Because people would just be too afraid to speak up?
Yes. The press would be terrified to investigate corruption. Citizens would be terrified to criticize their mayors or presidents.
So they decided that the collateral damage of occasional lies was worth the protection of the broader truth.
That is the paradox at the heart of the First Amendment. The court decided that a certain amount of messy, imperfect, and even inaccurate speech must be legally tolerated.
They called it breathing space, right?
Yes. They explicitly stated that freedom of expression needs breathing space to survive. They protected the ecosystem of debate, deliberately sacrificing the individual reputations of powerful figures to ensure the public square remains robust.
So what does this all mean? We have this incredibly rigorous standard for factual reporting and political critique.
Right, the Sullivan standard.
But we are talking about a comedian here, Trevor Noah. We have to layer the entirely subjective, chaotic world of comedy onto this rigid, legal framework.
And that's where the friction really starts.
Because political comedy isn't about facts. I mean, it is built entirely on exaggeration, irony, and satire. How does a court possibly distinguish between a damaging, defamatory lie and a protected joke?
The courts navigate that by utilizing the standard of the reasonable audience.
The reasonable audience.
Yes. They operate on the foundational principle that human beings understand context. A reasonable audience knows that a stand-up routine, a late-night monologue, or a satirical article is not a sworn affidavit.
Right, they're not watching the nightly news.
Exactly. They do not view comedic exaggeration as literal, factual claims.
It's like looking into a funhouse mirror.
Oh, that's a perfect way to look at it.
Yeah, if you walk up to a funhouse mirror, the reflection is wildly distorted. It might make you look terrible, the proportions are absurd, and, it might be deeply unflattering.
But you know what it is.
Right. A reasonable person knows they are looking at a trick mirror. They don't walk away thinking it was a literal high-definition photograph of reality.
And the Supreme Court formally protected that funhouse mirror in a landmark 1988 case called Hustler Magazine v. Falwell.
Oh, I remember reading about this one in the sources. It was brutal.
It was. Hustler Magazine published an incredibly graphic, deeply offensive parody advertisement about the prominent religious leader, Jerry Falwell.
It was a fake interview, right?
Yes, a fake interview that made utterly absurd, obscene claims about him. Falwell sued for intentional infliction of emotional distress, and he actually won in the lower courts.
Which makes sense on a human level. I mean, it was vicious.
On a human level, absolutely. But the Supreme Court unanimously overturned that decision.
Unanimously. Wow.
Yes, they extended First Amendment protection to this deeply offensive parody specifically because it was so outrageously distorted that no reasonable person could possibly interpret it as a statement of actual fact.
Because it was obviously a funhouse mirror.
Exactly. The court recognized that satire plays a vital historic role in public discourse. Satire challenges authority. It exposes hypocrisy. And frequently, its sole purpose is to make powerful people deeply uncomfortable.
And discomfort is not a recognized legal injury in the United States.
No, it is not. The law requires actual measurable damage to reputation based on a believable lie, not just hurt feelings based on a vicious joke.
Here's where it gets really interesting. Let's take all of this historical weight, the actual malice standard from Sullivan, the reasonable audience test from Hustler v. Falwell, and bring it crashing into our current pop culture flashpoint.
Let's do it.
Let's look at the exact timeline outlined in our sources. Trevor Noah is hosting the Grammy Award.
A massive stage.
Huge. And during the broadcast, he delivers a joke targeting Donald Trump. Now, political humor is baked into the DNA of modern awards shows. It is practically a requirement of the gig.
It is the established cultural architecture of that specific venue. The audience fully expect the host to punch up at figures of authority.
Right. So, following the broadcast, Donald Trump responds publicly. He takes to his platform, Truth Social, and posts a response that subsequently circulates like wildfire across platforms like X.
As things do today.
Exactly. And in this post, Trump suggests that Noah's comedic remarks were false, and he explicitly raises the possibility of legal action, a lawsuit.
Raising the stakes significantly.
Very much so. Later, Trevor Noah addresses the tension in his Netflix special, Joy in the Trenches, clarifying his intent and breaking down the absurdity of the situation from his perspective.
Which brings us to the legal reality.
Right. If you are listening to this, you might be wondering how an actual judge would handle this. Let's theorize. Applying the legal frameworks we just discussed, who actually holds the high ground here if this entered a courtroom?
If we evaluate the likely reality of a formal defamation suit, the legal framework provides massive, almost impenetrable leeway to the comedian.
So Noah has the advantage.
Overwhelmingly. First, the context of the speech is paramount. Trevor Noah was speaking in a clearly defined comedic setting.
The Grammys.
Right. The audience, both in the room and watching at home, was primed for humor. Furthermore, the target of the joke was a former president and global public figure.
So the funhouse mirror defense essentially forms a moat around the joke.
It does. A court would almost certainly rule that a reasonable person watching an award show monologue understands they are consuming satire, not a news bulletin.
And what about Trump's side of it?
On the other side of the equation, Donald Trump would face the absolute highest possible burden in American civil law.
The actual malice standard.
Exactly. He would have to clear the New York Times' Sullivan hurdle. He would need to prove with clear and convincing evidence not only that a reasonable person took Noah's joke as literal fact.
Which we just said is highly unlikely.
Right. But he'd also have to prove that Noah knew the underlying premise was a factual lie when he said it, or acted with reckless disregard for the truth.
Which is practically impossible to prove for a punchline. I mean, the law is essentially telling public figures that they have to develop a thick skin because the courts are not going to referee comedy.
That is the explicit message of the jurisprudence, yes.
But, you know, the strict legal reality is really only half of the story here. Just because speech is protected from a lawsuit doesn't mean it exists in a vacuum.
Not at all.
We're dealing with two completely separate ecosystems here. The rigid, slow-moving legal standard defined by courts, and the fluid, hyper-fast cultural standard defined by public opinion.
And separating those two ecosystems is essential.
Yeah.
Having the constitutional right to say something deeply offensive does not obligate society to applaud you or protect you from public backlash.
Right. The First Amendment doesn't save you from being canceled.
Exactly. The legal shield keeps you out of civil court, but it does not protect your career, your reputation, or your social standing. This specific dispute between Noah and Trump perfectly illustrates the modern cultural divide regarding the limits of rhetoric.
Yeah. Our sources highlight two very distinct, highly polarized reactions to this event. And looking at them neutrally, on one side, you have defenders of Trevor Noah's approach.
The comedy purists, essentially.
Right. Their perspective is deeply rooted in the historical tradition of the court jester or the political satirist. They argue that anyone who wields the immense power of a political office should absolutely expect relentless scrutiny and mockery.
Because of the territory.
Exactly. To them, comedy is a completely legitimate, necessary form of political accountability. They see the First Amendment as a tool specifically designed to punch up at authority figures.
Conversely, you have a counter-argument raised by supporters of Donald Trump, which centers on the modern information landscape.
Right, the speed of information.
Yes. Their perspective is that public figures, regardless of their immense power, still deserve basic protection from falsehoods. They argue that in an era where misinformation spreads globally in seconds, comedy should not be used as an impenetrable bad faith shield to launder false narratives.
So they think the funhouse mirror is actually dangerous.
In a way, yes. Their concern is that the line between valid, protected satire and harmful reputation-destroying misrepresentation is blurring too rapidly.
What fascinates me is that both of these deeply opposing cultural views are operating under the exact same constitutional umbrella.
They are.
They are both utilizing the First Amendment to make their case.
If we connect this to the bigger picture, we have to examine the actual mechanics of power and platform in this dispute.
Okay, lay that out for us.
When a comedian speaks on a stage, it is framed and consumed primarily as entertainment. It has cultural influence, certainly. But when a president or a former president responds publicly, it carries entirely different weight.
It's massive.
It instantly commands the global news cycle. It marshals millions of followers.
So wait, let me make sure I'm getting this. Even though Trump was aggressively threatening a lawsuit, which sounds like an attempt to silence someone, the mere act of him posting his response on Truth Social is actually him utilizing the exact same First Amendment that protected Trevor Noah's joke.
That is the brilliance and the friction of the system.
Wow.
Trump's response was not an act of state-sponsored censorship. He did not dispatch the Department of Justice to seize the broadcast tapes or arrest the comedian.
Right, because he's not acting as the government in that moment.
Exactly. His response was a textbook example of counterspeech. The entire underlying philosophy of the First Amendment is built on a very specific premise. The remedy for speech that you find offensive, false, or damaging is not enforced silence. The remedy is more speech.
You fight words with words.
Precisely.
If you don't like the joke, you take to your own platform and tell the world why the joke is wrong.
That's it. In this specific scenario, the constitutional framework is functioning exactly as it was designed to. Noah is exercising his rights through satire and broadcast entertainment. Trump is exercising his rights through public criticism, platform mobilization, and, yes, even the vocal threat of legal action.
Both are engaging in the messy, loud reality of the public square.
They are.
Let's talk about that threat of legal action, though. Because while more speech sounds like a perfect, balanced solution in a textbook, reality is much messier.
It always is.
Our sources bring up a major concern regarding the weaponization of these threats, something legal scholars call the chilling effect.
Ah, yes. The chilling effect.
Because, let's be entirely honest here, even if you are a comedian who is legally in the right, even if you are guaranteed to win the case under the Sullivan standard, fighting a defamation lawsuit is exhausting, terrifying, and wildly expensive.
The process itself becomes the punishment.
But the process is the punishment,
Yeah.
exactly.
And that is where the tension becomes acute. A massive public figure doesn't necessarily need to win a defamation suit to achieve their goal. They simply need to file it, or even just credibly threaten it.
Just the threat is enough.
Often, yes. The sheer financial terror of defending a lawsuit can discourage everyday citizens, independent journalists, or less prominent comedians from speaking freely. If you do not have the vast financial backing of a major television network to pay your legal fees, you might decide that the joke just isn't worth the risk.
So critics of this tactic argue that when powerful figures routinely wave the threat of litigation around, it slowly degrades that breathing space the Supreme Court tried to protect.
It forces people to self-censor.
Right. But, keeping our lens strictly analytical, the opposing viewpoint argues that the right to seek legal redress is also fundamental.
It is a core right.
Proponents of robust defamation laws argue that public figures should not be forced to act as defenseless punching bags. They argue that these legal mechanisms exist to deter genuine malice, and that threatening a lawsuit is simply a public figure demanding accountability in a media environment that often rewards outrage over accuracy.
It is an incredible, constant push and pull.
It really is. Looking at this clash between a comedian and a president, what truly stands out is how sharply it highlights the invisible boundaries of our society. On one hand, the law fiercely protects Trevor Noah's right to stand under the lights and hurl exaggerated satirical jabs at one of the most powerful people on the planet, insulating him from government retribution.
And simultaneously, that identical law protects Donald Trump's right to fiercely criticize the comedian, to rally his supporters, and to leverage his massive platform to dispute the narrative.
It manages to accommodate both actions while keeping the barrier for an actual lawsuit incredibly high.
Ensuring that the argument stays in the realm of public debate rather than the courtroom.
The system isn't designed to eliminate conflict. I think that's the biggest takeaway for anyone listening today. We look at the First Amendment and we want it to resolve our arguments, but it is actually designed to contain the conflict within a framework of open expression.
That's a very precise way to phrase it.
These moments, like the Grammys flashpoint, feel like dramatic, fleeting celebrity culture clashes, but underneath the surface, they are actual high-stakes constitutional case studies playing out in real time.
Everyday stress tests of the system.
Exactly. The First Amendment does not guarantee that the speech flooding your feeds will be polite. It doesn't guarantee it will be accurate or fair or that it will be universally accepted. What it guarantees is that in the vast majority of cases, that speech will not be silenced by the state.
In a society that is constantly attempting to balance a profound dedication to free expression with a very human desire for accountability and truth, that constant grinding tension is not a bug in the system.
The tension is the feature.
It absolutely is.
Please note our mandatory disclaimer before we go. The Diary of a Lawyer and all its content published is strictly for educational and informational purposes only. Nothing presented here constitutes legal, medical, or mental health advice, nor does it create an attorney-client relationship and does not constitute professional advice. Please be sure to consult with a qualified professional in your jurisdiction regarding your personal situation for advice that is tailored to your specific situation.
We established today that the constitutional remedy for speech you don't like is more speech, counter speech. But as you navigate the digital world today, consider this.
Yeah.
The First Amendment was written for a time when everyone essentially had the same size soapbox.
Yeah.
What happens to that fragile constitutional framework when invisible social media algorithms, not just human voices or the validity of an argument, get to decide whose counter-speech is instantly amplified to millions and whose voice is permanently buried in the noise?
It completely alters the balance of the shield and the sword. Thank you so much for joining us on this deep dive. Keep questioning the frameworks around you, keep looking for the underlying mechanics, and we will see you next time.